My colleague did part one, and I'll be doing part two for this month. First, we'll do the aim of the webinar. Why this webinar? Secondly, we will do general overview of the regulatory framework. And then we'll look at developments in the data protection space. And here, we look at case law and we look at various cases that have been decided by the Office of the Data Protection Commissioner and how they apply to us in this webinar with your friend or your family member. Then we look at the industry impact and response, and the best practices, and then we can conclude. So the aim of this webinar is to explore the recent developments in the data protection space that have emerged over the past month, that is September. The session will also delve into best practices that can be adopted by organizations to enhance compliance and protection of personal data and more effectively. But by addressing these timely issues, the webinar seeks to provide practical insights and actionable strategies that can help businesses and professionals navigate the data protection landscape. So when you talk about data protection, what laws in Kenya apply and how and where can I get these laws? First, the data protection law came in force in November 2019. This is just a background for us to understand what is this data protection I'm talking about. So the Data Protection Act is primarily the center of processing personal data. When you talk about data protection in Kenya, the first thing that clicks in our mind is the Data Protection Act. And the Data Protection Act has various regulations that supplement the Act. First, we have the Data Protection General Regulation of 2021. We have the Data Protection Registration of Data Controllers and Data Processors Regulation of 2021, and then the Data Protection Compliance and Enforcement Regulations of 2021. We will see as we go along in our webinar how these various regulations have helped in deciding cases. They have helped in solving the unique cases that we're going to see and look at them, because cases are different and we know case is precedent. But how do this act supplement, or how do this act help, or this regulation help the ODPC make decisions and judgments? Even the courts, how do they use these regulations? We are going to see that. Just a brief overview, principles of data protection, which we are going to see how effective and how keen we ought to know them. These are found under Section 25 of the Data Protection Act, and the various principles include lawfulness, fairness, and transparency when we talk about data, purpose limitation to be used only for the specific purpose that they were collected for, data minimization as little as it can be, the accuracy, straight to the point, and storage limitation. How long do you seek to put this data? And we're going to see how the ODPC poses these questions to the various respondents who are brought before them. Right to privacy for the data subjects, and then the transfer of data. When you talk about transfer, is if your data is being transferred, mainly if you look at international bank, international organizations, if they transfer your data locally, out cross-border transfer. Let's have these principles at the back of our minds, because when you look at these cases, you will see how critical they look at each and every principle and they dissect it and make meaning out of it. The developments in the data protection space. All these cases that we look at have been decided in the month of September. Just a few of them. The ODPC have decided 8 cases in the month of September, but we are going to look at 5 of them, which I feel have affected various industries and which they are a bit rampant in the current space that we are in. So when we look at these cases, at the back of our minds, let's try and look at the facts. Let's try and relate to the facts as individuals as well. And also look at how the ODPC was able to decide and determine the case. So just a disclaimer for the people who are not legal in the platform. When the ODPC decides the case and you're not satisfied with it, you have the right to appeal within 30 days to the High Court as you proceed. So these decisions are mainly from the Office of the Data Protection Commissioner, which is a regulatory body that regulates data protection in Kenya. On to the start. What happens? These are just rhetorical questions I would want you to just think about. What happens when your insurance service provider leaks your medical history and personal data to third parties. This might have happened to you or it might have happened to your friend. Let's look at what the ODPC did about this case. So the case is SMM versus the AR Insurance Kenya Limited, ODPC complaint number 842 of 2024. This is the allegation. So the complainant alleged that the respondent, without obtaining consent, shared his family health insurance information with a third party, who subsequently sent him unsolicited messages about his family medical plan. We have talked about the principles of data protection. Let's look at the brief facts of this case. So this case, when you read it, you will see when the complainant lodged this case in April, the ODPC started the investigation and he heard the both parties. And now the facts were the respondent in October, 1st of October in 2020, entered into an agreement with a third party. And this third party who entered in this agreement was called Carry Pay Limited. And why was the main agenda of why they were contracting the third party is because the third party had a service that he was rendering to the insurance. And the service was to transfer the administrative scheme of to transfer the old administrative scheme of looking at the insurance policies of people to a digital platform. We're all moving digital, so that was the service. So the insurance organization here, which is the respondent, contracted the third party. When they contracted the third party came up with a platform called the MTBA platform, which I suppose maybe someone in the platform is part of is part of the scheme. So when they contracted the the third party in this case, to provide the service on the MTBA platform. So the MTBA platform is a platform where it isn't the process of a patient to contact a doctor. That is their selling principle when they sold it to the AAR Insurance Kenya Limited. And if you were the respondent, you'll be like, wow, this will ease our work. So why did they contract them for their defense instead? First, this will even reduce the cost of us hiring a whole software where we are able to look at all those policies and schemes for our patients. Secondly, this is one, it's less, the system is, we can be able to track, we can track the records. Two, it's less costly. And three, it's easier because the patient will be able to even look at their data history, their medical history from the platform. Correct. So during that is the basic service that was being rendered as per 1st of October 2020. Then comes 15th December of 2023. The third party says we have an extra service. So for the people who do not pay for your services as an insurance company, we can be able to do claim settlements or debt collection for you guys. So the insurance company goes and says, correct, that's fine. Let's enter into an agreement. So what we can do is we can share this data we have for our patients. Now this is where it's getting crazy. So where we are going to share this data for our patients and transfer them to you guys for you to see the people who have not been able to pay and they want to have been paid so that they can be cleared of the system. Correct. So as per 15th of December, that was the agreement. Moving on. So as 15th of December 2023, they agreed, they signed. When they looked at the partnership agreement, it said in a clause in the partnership agreement, it was saying that all the data sharing, it will be used for the specific purpose. It applied all the principles of data protection, which was good as we continue. So when they transferred all the data, as from January 2024, all the inpatients of the insurance company were transferred into this system at a third party. However, but the data subject informed that your data will be transferred to another platform so that you can be able to know all this information we're trying to do. Correct. So the claimant brought the case to the ODPC and said, This information, I was not aware. I was not aware my information is being sent, and I can see I'm being sent messages from so and so. When did all this happen? When I was signing the contract with you guys, I did not sign to be getting these messages. I did not sign up for this. However, the respondent came forward and said, we sent messages to all patients telling them that we are transferring our identities from the old administrative scheme to the new MTBA platform. The complainant says, I was not aware. I was not aware that my data and my family members' data will be transferred to this system, and you will be sending us messages claiming the money we have not paid. Correct. So the ODPC looks and assesses the issue. What do they resolve to? They look at it, and when the respondent is asked, did you send a message to the complainant saying that you have been able to transfer their data from the old administrative scheme to the new scheme? And they said that there was an error. There was an error when we realized that we did not we did not send a message to the complainant. And now that was the greatest proof. What did the ODPC do? The ODPC went to the act. And in their act, they were able to see, wow, correct, this did not happen. So how will we settle this dispute? According to now, there are various sections. When you look at section 26, when it talks about rights of a data subject to be informed that their data has been transferred for correction of their data, that is what they enforce. And when we look at section 29, when it says the duty to notify, the duty for the data controller and the data processor to notify the data subject that their data is being transferred from this platform to this other platform. That was a major problem. That was a major problem that they did not do. What was the final conclusion? So the respondent was ordered by the ODPC to pay the complainant 25,000 as compensation for that. Does that case seem familiar, or to a familiar circumstance that your friend or your family member or you yourself have gone through? Mm-hmm. That's one of the cases. Let's look at the second case. Great. What happens when your personal data is used for commercial purposes without your consent? Hmm? There was a case on this. Then we have Christine Otala versus the NSSF fund in another. This is the ODPC complaint number 817 of 2024. The brief facts. The complainant alleged that the first respondent, that's NSSF, published and circulated her video without obtaining her consent, and that it benefited it financially without compensating her. This has happened, and we have seen so many people complaining that I've seen my picture, I've seen my video used for marketing, and I did not consent to it. There was a unique case before the OTPC. Let's look at how they reasoned it. Let's look at the brief facts of the case. So the brief facts of the case were the complainant was given a call by one of the representatives of the the National Social Security Fund. And the representative said they have looked at the profile of the complainant, that's Christine Ochola, and they have seen she has a YouTube channel, and they can use her to be able to market NSSF services to the retirees employees. Correct. So she was like, oh, this is interesting. I am ready, and we can be able to further this conversation. So how should we proceed? However, there was a disclaimer by word of mouth. The representative of the National Social Security Fund and said, but we do not have budget for this. We do not have money to pay for your services. However, we have an appreciation gift, a token of appreciation, which is 20,000. And then you're going to give us your video, we are going to use it, and you're going to engage you further if we see this good feedback for this particular video. So the lady was like, okay, let me just think about it, and then I'll get back to you. So the following day, the complainant went back and said, all right, I think we shall proceed. Let's just have this one service that I offer to you guys. You see how my services are. Then if you're satisfied and you get good feedback, you can come back to me. Correct. So just after that, the complainant said, however, let's do this in writing. the complainant. She said, Christy, this is Christy. Can we just do this in writing and say that you will not use my video until you've paid me the 20,000 and have looked at the agreement that you seek to engage me further if you get good feedback. And they're like, all right, let's take the video. And then before we release it and publish it in the commercial spaces, you're going to send you the contract for you to sign. She's like, all right. So how do you want me to record the video, the nitty-gritties of recording the video, etc., etc.? She's like, all right, we're going to send you the questions. When she looked at the questions the questions were all about marketing of NSSF. She's like, all right. So if I help you guys as a digital marketer and an influencer for NSSF, you're going to give me a company an appreciation of 20,000, but you'll engage with us. She's like, yes, that is it. That is fine. So they recorded the video and they did everything else as it was supposed to be. And then they went and they tracked back and they edited the video. Now the third party in this case, who the second respondent was contracted by National Social Security Fund to do what? To be able to take the video, to be able to edit it, and to do the digital marketing of this video. It's like, all right, so you're the one who's been contracted, etc. Such kind of agreement. They're like, this is fine. So once they finished recording and editing the video, the parties waited now for her to be sent the contract, for her to sign, so that the video can be disseminated to the people. Now, this is where the loophole comes in. The video was disseminated to people and the commercial spaces without her having had signed the contract. It was done without her consent. She did not consent to the disseminating of her video and of her image without first having signed the agreement. And she was not aware. So in the facts, she says, I got calls from people, and actually, she saw herself on national television advertising, and she did not agree for it to be advertised if she had not yet gotten a compensation and fined. So she lodged a complaint to the ODPC. And the ODPC were able to look at the complaint. How did they rule about it? They looked at it and said, there are various principles of data protection, which we looked at section 25. And one of the principles that you have violated for Christine is transparency. You are not transparent with her. You used her video. However, you did not tell her that you will be using it. Even if, at some point in the brief fact, it seems that the video was used in a luncheon in the NSSF ceremony or a conference, and she was not aware. So she was marketing for NSSF without her knowledge that actually her video is being used. For her, she thought her video is being stored, it's being reviewed until they get budget so that they can now employ her. No, no, no. However, they were using it at the back, behind her back without her knowing. So how did they look at it and what conclusion did they make after looking at that set of facts? Looking at the principles of data protection under Section 25, they violated the transparency principle of data protection. What else did they violate? They also violated Section 25, Section 37, which talks about commercialization. That you do not when you use personal data for commercial purposes, you do not use it for commercial purposes without the consent of the personal of the data subject, without the consent of the data subject. So after that, they came to a conclusion that actually, because NSSF had contracted the second respondent, and the second respondent was the social media or the digital marketer of NSSF, NSSF was not liable because they had subcontracted someone to do that. So when they looked at the second respondent, who was the one taking videos and doing the marketing, who was to send her the report, who was to send her the agreement, and they did not do that. And they went ahead and aired her video to the national television without even the consent of her knowing that she'll be aired. It was liable because it's a company. So the second respondent was found liable and was ordered to pay compensation of 450,000 to the complainant. And this is a very rampant issue where you see your picture is being used, your video is being used, you're told to come and record. However, they do not follow the right procedure. They do not pay you, they do not give you the agreement papers, they do not even let you know that they'll be using it and getting monetary out of it. Because when you look at it, NSSF was able to benefit because many retirees came and banked for their retirement with them without her knowledge. She was not even given a portion of that. And that's why she went and complained about it. And you can see the ODPC ruled in her favor, and the second respondent was ordered to pay 450. When we look at these cases, and why are we looking at these cases? We're looking at them first to create awareness to all of us and say, do not sit on an issue just because you're not sure how it will end up. Cases are unique, however, the data protection covers you as a victim subject. But when you look at it, your picture maybe is used by a restaurant and you did not consent for that, you look at that. Let's go to the third case. Great. How can I address all these unsolicited messages from marketing companies? I think most of us get them. If you look at Uber Eats, if you look at Jumia, if you look at Uber, did you consent to the receiving of these messages? When you look at supermarkets, did you consent to that supermarket sending you offers? Did you? And why are they sending them to you? How do they access your data? Correct. The case of Catherine Wairimu Gabriel versus UMA Microfinance Bank ODPC complaint gives us how the ODPC ruled about this. Brief fact. The complainant alleged that the respondent sent her direct marketing messages without her knowledge or consent. First and foremost, if you read the facts of this case, the complainant was not a client to the respondent. And how were they able to access her data? And to look at the facts, the respondent says that they were able to access her cell phone number through her Facebook page where she runs a car hiring service, and they were able to take her number and send her their services and market their services. Why would a company do that? And you as an individual, what course of action can you take? And when you look at section 37, well, we'll see it will apply in most cases. And I will really urge all of us to familiarize ourselves with the act and also these good cases that we're going to see. These good sections, we're going to see, I repeat, the ODPC emphasizing on certain sections that you all need to know. Section 37. Section 37, as we had said earlier, talks about the commercialization of data. And you need to consent to that. For our complainant here, did not consent to getting such messages from a bank she was not banked with. Correct. So how did the ODPC rule on this? They found that the respondent had violated first principle because she did not consent to that, and secondly, they used her data wrongfully without even notifying her according to section 29. So the determination was the respondent was ordered to erase the complainant's personal data from its records and stop sending direct marketing messages to the complainant within 14 days after the delivery of the determination. Great. So we can see we have a course of action. If you see you have a course of action, you have an issue like that, you're getting so many messages from microfinance banks, these are Akinatalas and the Fulizas and all those people, and you've not consented and you're not even part of a client, there's a course of action here. You've seen how the ODPC ruled and those ruled. Great. To our fourth case scenario. What happens when you find out you're a guarantor to a loan you are not aware of? This is crazy. And we all know, or some, if we do not know, if you're a guarantor, if the person who took the loan defaults to pay, you pay. All of a sudden you wake up in the morning and you're being called that you're a guarantor to a loan to a circle you are not aware of. What do? Let's look at the brief facts. The complainant relates to the alleged contacting of the complainant regarding a loan that he was not a party to. and had not consented to be listed as a guarantor. First and foremost, they did not even know the person who took the loan. You can see how your data is sensitive and the use of how various companies are misusing data, may it be your email address, may it be your home address, may it be your cell phone, may it be various types of personal data that we have, medical data. See how various companies are misusing them to their advantage. Let's see how the ODPC ruled about this. So the complainant said he was being harassed by the respondent through calls and messages regarding a loan by one of his clients. The complainant went forth and said, I am not party, I am not a client to your services. I do not know how I am a guarantor in this. And I don't even understand because if I was a guarantor, according to Section 29, I ought to be notified. I was not notified that someone had put me as a guarantor. So how did this happen? You've been calling me, you've been sending me text messages that I should come and settle the loan. This is wrong because now they went even ahead to even send text messages to the family members that so and so party X, this is Lawrence, owns is a guarantor and he should settle this and he should settle this claim for the he should settle the debt. You can see that is causing distress to the complainant. When the complaint was lodged, the ODPC went ahead and addressed the issue. And they went ahead and talked to the respondent. However, the respondents did not come forward. They did not even come and say that actually this case goes this is like this and like this. They did not appear short. Just by saying that precisely, they did not appear in the complaint. So the ODPC went ahead and having grounds through Section 26 of the Act, which talks about the rights of data subjects, they are able to say the data subject ought to be informed. You ought to be informed when your data is being embodied in something that you do not know because it's your personal data. So what did they determine? The determination for the ODPC, they said the Data Protection Commissioner ordered the enforcement of notice against the respondent to stop and erase the data of the complainant from their database within the next 14 days after the judgment. So where you see that your data is being used by microfinance bank or it's being used by a particular company and you're not aware and you're not even party to it, or maybe a company or an organization, most of these organizations through the algorithms of your internet searches and everything, they're able to get your data and look at maybe your email address that we always press autofill. They're able to just come and access that data and send you services just as marketing to themselves, or even they embody you without your knowledge. So we can see we have a weapon here. What's our weapon? We take it to the ODPC and they're going to rule to our paper depending on the circumstances of the case. Let's look at our last case scenario for this month. Great. Can I sue if my data is used to take up a loan I am not aware of? Just think about it. With the current harsh economic conditions, someone just takes your data. They take your name, they take your mobile number, they take your bank details, and take a loan on your behalf. How does this even happen? If you think critically, you're like, okay, even if it's a credit company or a bank, how was someone able to take my data and do a loan? Correct. So let's look at the facts of the case when the complaint was done. So the complainant said he got calls from the respondent. Who say they got his contact from a customer who owes, okay, sorry about that. So the complainant said he got calls and messages from the respondent, in this case, who is Azura Credit Limited, to be able to settle a loan that he did not know about. So he said, how was this possible? And how did I pick up a loan I am not aware of? There's a point of signing, there's so much that goes on before I take a loan. So they were not giving him time to hear, they were not hearing him out. So they threatened him and said, they're going to take you to the limit, they're going to take you to the credit reference bureau so that you can be blacklisted. So the complainant went forth to the ODPC and said, I was not aware of all these things that are happening to me. I was not aware of this loan. I'm not aware of the service provider. I am not aware that my details were taken by a particular person and all those things. So as part of the procedure, the ODPC went ahead to investigate the claim. So they went and approached the respondent and asked, is this true? They said, yeah, if you look at this mobile number that's being alleged that called, this is actually our mobile number. And this mobile number is used by our agent. And our agent calls the people who have defaulted to pay their loans. So they ask, is this complainant, sorry, is this complainant part of your client? They say, all right, let's check in our database. So they went and checked their database. However, when they were coming to do the investigation, the respondent says their ICT person isn't there and they cannot be able to access and see if the complainant is part of their client. The OPPC says, no, this is wrong, this is violation because you're restricting us from looking at your database because currently we are doing an investigation for a claim that has been made. They go ahead and say, no, our ICT person is not present, is not here. So what you're going to do is you're going to come back after 3 days when they're going to come back. So the ODPC went back and did their decision and looked at the evidence that was brought by both parties and just looked at the whole set of how the case played out. And once they looked at the whole case, violation of section 26, the rights of a data subject, they ought to be informed. How can someone take a loan without you knowing? It's a great loophole. How can someone even use your data, let's say your phone number, your email address, and etc.? Someone will go to the bank, put your name, put your mobile number, put your email address, but you see they'll sign and everything else and all those shenanigans. However, you ought to know. They ought to send you a message before they start calling you and telling you, oh, you have defaulted. And also, remember, they violated something else. They violated the fact that they prevented the what do you call them, the personnel, the people who go to do the investigation at their premises. They hindered them from doing the investigation. According to Section 65 of the Data Protection Act, that is an offense from prohibiting the ODPC from doing its investigation. That is a major offense. So what did the ODPC rule at the end of it? The complainant was ordered to pay the client 250 shillings as compensation, but for the distress caused, sending him text messages threatening him to blacklist him for a loan he is not aware of. So look at that, because even being in the legal space, we get a lot of claims on this. They say I have been threatened by my credit service provider. They are saying they're going to blacklist me or they are going to do this and this to me because I've defaulted to pay this, and you're not even aware of that. So it will be to your advantage to know your rights as a data subject, to know the principles according to the Act. When do I ought to be notified? And what does it mean to lawfully process my data? As a data processor and as a data processor and as a data commissioner. Great. What are the industry impacts and response to all this? What is for the various industries? We look at the telecommunications and the finance services. We've looked at the various cases. Those are among the 8 cases that were decided the month that has passed, that's the month of September. So when we look at the various cases and how the ODPC was able to analyze them and rule them, what are the industry impacts and response? First, for the telecommunications and the financial services, which is a major um, sector that we are seeing a lot of these claims. These sectors handle vast amounts of sensitive personal data daily. In response to the developments that are happening, here are some of the things they can do. One, adopt advanced encryption. This is to secure a customer data in transit and at rest. And we remember the first case that we dealt with. How is my data as part of your client and your insurance agency? How is it being transferred to a third party and I'm not aware of, and I'm getting messages? Mhm. Implement transparency measures by updating customers on how their data is collected, stored, used, and ensuring that consent is actively sought for any new purposes. This just clearly repeats our first scenario. Even if you're a company owning this platform and you're upgrading your system and you want to use your system, you want to get consent from your clients for them to actually understand first. For consent, the person has to first comprehend what they're signing up for. If I was a client, I'm in an insurance company, I need to know what this MTBA platform will do, what data you will collect from my family members. When you talk about health status, that's a very sensitive matter. When you want to connect me to a particular doctor, how are you aware of such information? Did I freely give that information? So implement transparency measures. Three, strengthen data access policies to limit who can view, modify sensitive information, safeguarding against breaches and unauthorized access. This happens where they contract third parties. When we look at that case scenario for Christian, the second respondent, who was contracted by NSSF, was able to take the video, market the video, without even sending the agreement to the the complainant, without even the knowledge of NSSF, went ahead and launched it in their conference without her knowing. She's getting this from other people saying that, oh, we have actually seen you on national television, you're doing a good job and all those things. No, no, no. So who can access this data? And when this data is accessed, do we have measures on how it can be used as an organization and who will know about it and does our data subject know? Fourthly, regular audits in data protection impact assessments should become a routine to identify and mitigate risks, ensuring continuous compliance with regulatory changes. This was one of the allegations. When you look at that insurance company that we have just looked at, what did it say? The insurance, it said it was an error. They were not aware that they had not migrated this particular client to this new platform. Wow. Even if you as a data subject, that's a major loophole. So all this time, since 1st of January 2024, I've been getting messages and you're not aware that you did not send me a message in December 2023. If you had done your data protection impact assessment and regular audit, you would have been aware. You would have known that this particular client, that this particular set of bunch of clients, this particular sector of people, maybe you're dealing with a corporation or corporates, they are not aware of this. And this will even prevent you from even paying all these fines and all these offenses, and you'll be able to vindicate your organization or even for your company, for the people in the platform. As an individual, be aware of all these things. For the financial services that you're a client to, are you sure they're transparent with you? How is your data kept meted with them? Do they do data protection impact assessments? If you've paid off a loan that you took, but you still get messages of repay your loan. Oh no, you within the 30 days you're going to blacklist you and you cleared off your loan. So why am I still getting this? That's a red flag because it means they have not updated them. Great. The healthcare industry. First, educate staff on data protection to ensure everyone is aware of the rules around patient data handling, especially on medical professionals, how they interact with large volumes of sensitive information. Like for the first case that we dealt with for SML and AAR insurance, the particular complainant goes ahead and says, for my family, all our medical history is out. Who did this? Like how did they access our data? Was it legal for them to even process my data as a family? And where are they sending us messages and all these things and how we can sort out a particular illness that we have? How are they aware about it? Mm. Point two, emphasize patient confidentiality by investing in secure cloud storage for health records and implementing strict access controls. Thirdly, develop incident response plans to handle data breaches swiftly and efficiently in line with reporting requirements under the law. Where there's data leakage of your particular patient, how promptly, within the next 24 hours, will you have sorted it out? Now, for that particular insurance or the particular hospital that you have secured the insurance policy with, how is their data incident response? When the doctor takes your data, will you hear someone else hear about your case or hear about your particular um, current or or not your customized, but your illness, you'll hear it out with people. I can give you a very good example. One of my friends had a very unique disease, a disease that doesn't have so many people in the country, and there's no medical, there's no medicine that can treat that particular disease. So it's only one hospital in the country that is able to treat that disease and just help her moderate it because it's a terminal illness. That is sensitive data. That is data that should not even be known by even when you call your acquaintances and colleagues at work. That is very personal. So one day, as she was going to hospital, and because for the country is still trying to find what do you call it? They're still trying to find medicine to cure this particular disease. So she's used as a guinea pig, sorry if I can use that, to get um, the best medicine that can be able to cure this disease. And she consented to that. She said she's ready, she can be used for that, if that's the impact that she's going to cause or she's going to be of beneficial to the rest of the people who the current, I think there are 5 people in the country with that kind of disease. Tell me why she walks one day for the normal procedures she has, and one of the nurses says, "Oh, you're the patient who has this particular disease." Mm. And then the rest of the nurses around her actually they exclaim and say, "Wow, all right, she's a particular patient with a particular disease." They enforce confidentiality, but she was able to get justice. So look at that and do not take it lightly when your data is breached. Great. Government and public institutions. Public institutions handle massive volumes of personal data, making compliance crucial. First, invest in robust data security systems to protect the personal information of citizens, particularly as more service move online. Tax filing, public service access. I've heard a lot of Kenyans complain now that they're being called by the Kenya Revenue Authority that they call you so and so, Jane. I know you have a building at this particular area. I know you have a building at this particular area. You have this place that you have not paid taxes all this time. Then you ask yourself, all right, here again, they can access my data. And how comes I'm being called by an agent about this thing? How did they get to know my information? Avoid the tax filing and all those things. Right now, most of the government platforms are on the e-citizen, where there's a platform for Boma Yetu where you can get the affordable housing platform where you even put your bank details when you want to purchase an affordable house and all those things. That is sensitive data. Where place you're putting your bank details, your home address, and all these things, the government needs to have put the system in need so that they cannot be able, so that not everyone can be able to access your data. Two, ensure data minimization practices, as limited as it can be. Straight to the point. Why do I need your data? I need your number so that I can call you, so that in case of this and this, speak straight to the point. By limiting the amount of personal information collected and stored, only retaining it for the necessary period. I mean, they need to erase that. And the government, the old system, they need to do a lot of data impact assessment. Three, enhance accountability by appointing a data protection officer responsible for overseeing compliance across the various government departments. Great. So what are the best practices if you look at it? Firstly, implement artificial intelligence transparency and accountability framework. With AI systems increasingly being used to process personal data. And I was just looking at a particular bank service that is being offered by a particular bank in Kenya, where you no longer need to open a bank account physically. You can open your bank account by using your cell phone. So how is this encrypted and who is this responding at the back of the platform? Is it an artificial intelligence system? Is it AI? All right. Organizations need to ensure these systems are transparent. Regular audit algorithms to avoid biasness and ensure that they don't infringe any individual privacy rights. Two, comply with new data residency laws. In 2024, Kenya has seen an increasing push towards data sovereignty with regular emphasis on keeping certain categories of data within national borders. And this we have seen with a lot of politicians and prominent people. They have offshore accounts. They have money put in various bank accounts that we do not know. They have properties that we do not know. And all of a sudden, we are able to know there's land in Dubai or there's a house in Dubai that is owned by a certain person. How? That's data control, cross-border. That's about data. Adopt breach containment strategy. In case of data breaches, automated containment measures within the next 24 hours, we need a response. We have seen a loophole in my data of this particular client and all these things that have happened. How can we respond to that data breach within the next 24 hours? Transparent data collection practices. I need to know. Just look at that. Let's just remember the case that we were handling for Chris. We have just read about for Christian. I need to know if you have declined contracting me for this particular service. You've used my video. My video is all over the media. My video is all over national televisions, being aired at prime time. I need to know, transparent with my data. Ensure that the users can immediately see what data is being collected, why, and how it's being used. Real-time notifications about data accessed by third parties create transparency and build user trust. All these loans being taken, mysterious loans, I do not know. I have taken a loan, but apparently I am in debt. I need to know. You need to know. In conclusion of all this user development, as data regulation in Kenya evolves, businesses need to go beyond basic compliance by adopting new technologies and practices. As a data subject, you do not need to be sorry for protecting your data. You ought to protect it. You ought to guard it with all that you have. And having been aware of all these things, being knowledgeable of the Data Protection Act, the regulations there, and the place that the ODPC plays, you do not need to sit on that issue anymore. This includes strengthening security with advanced encryption, ensuring transparency with dynamic consent options, and improving privacy through decentralization systems. By staying proactive and focusing on these updated strategies, industries can better protect personal data, meet legal requirements, and build trust with their customers. Yeah, that's it for the September update on data protection and the recent developments. Those are cases you can find them in the media, just read through them, and you can look at you can tailor you can just read through the various cases and see how maybe your data has been infringed, your friend's data, your family member's data has been infringed. And with that, ladies and gentlemen, thank you so much for listening. I can see we have questions on the chat box. Yes, my colleagues will be able to answer the questions. I can see Motoni is on the platform. Thank you so much. And now she can be able to take it from me. Asante.
So, Annette, before we release you, just a minute. I think there's some thank you notes from some participants. My apologies. My good name is Mudhoni Njogu. I'm the managing partner of Njogu and Associate Advocates. Thank you so much, Annette, for such an insightful conversation. I do hope that most of you have learned something. And I think most of the comments on the chat session says, thank you so much, Wakili. Thank you so much for your presentation. Somebody actually used the word wow. Sounds like beautiful. Thanks for sharing knowledge. So I've started from the bottom going up. And then I think Mwenda Morris says, at one point in a hospital, I had a doctor telling a patient in front of everyone, you are the high risk patient. So I think time is coming so that now if you're fined for protecting somebody's privacy, it's high time so that we don't, I think that also has an element of discrimination according to the Constitution, right? I should not be discriminated because of the disease that I carry. So over and above data protection, data privacy, there's also an element of constitutional violation. That should be Article 27 of the Constitution that talks about discrimination. Nobody should discriminate against you. Going up again, I see Purity Lewa has a question. Hello, could you please advise if it is appropriate to send email communications to customers regarding consent, particularly for those whose data we collected before the introduction of the DPA? Annette, should we right the wrong? Because I hear fines, and more fines. Should we right the wrong? So they used to collect a lot of information, and now the DPA came into force 2019. So the question is, do we send an email for purposes of consent? I think you have mostly covered that in terms of the case conversations, but just to reiterate what you have just said.
Oh, great. So, if I get the question correct, after the act came into force, that's in 2019, there were companies that were still sending you emails and telling you all these things. Now, they ought to be compliant.
Yeah.
They don't have any reason of not being compliant. They have no reason to tell you the act came in force after we started implementing it. There is no such an argument. They ought to be compliant. You ought to give your consent. You're a data subject. You're empowered in the act.
Absolutely. So I think that answers the question. I know Annette had really answered that question when she was talking about the consent. Even if you go back to before 2019, that's when we say the laws do not apply retrospectively. Now you're in a new era where you need to right that wrong because that customer can now take you to court within the powers of what Annette is calling your rights as a data subject. They can actually now take you to the ODPC and enforce their rights. And I don't think we all have some loose change which we want to be paying people when we could actually do things in the legal way. I think the other question, she gave a bit of more breadth to her question. She said, how are other organizations handling this in compliance with the regulations? I think that is self-explanatory from what you have just said before. Vusi said, insightful presentation as a data protection officer in Eswatini. I'm learning a lot. Riziki said, greetings from Tanzania. Could you please share your slides? I think you've already covered that. Let me see more questions below here. Wonderful session. Indeed, it was worthy to join. Thank you so much, Annette. Thank you so much. Jane says, I'm definitely looking forward to the next. I'm currently undertaking my short course on data protection, and this session has been a plus. Boniface, you say, speak to the ignorance of data subjects on their rights. Speak to the ignorance of data subjects on their rights to their personal data. It is so funny that somebody has just shared with me, I think he's on the call, he has just shared with me the way a supermarket has been sending him messages because he paid via M-Pesa. Please, if anything that you take away from this is your right to privacy, period. That's it. Nobody should be sending you anything that you have not consented to receiving those messages. So they say ignorance is no defense, so do not use it. Please know your rights and at the same time, do enforce them. And then Wanda Morris says, we have organizations that send promotional messages and you haven't consented to them, nor shared your details. What is the best approach? Maybe Annette, you can just tell it to us again, because I know you had touched on it.
Great. This is one of the cases that we have just looked at. The case of Lawrence. They were not aware of a loan. They were not even aware that UMBA actually provides microfinance with limited, what do you call it, interest. They have cut their interest down. When you take the case, you see they had not consented. They are not even party to the UMBA bank. And now they are getting all this, and we've been able to see the ODPC, they were able to knock it on the head and say it is wrong. And actually, they enforced Section 26, the right of the data subject. You ought to be informed. You ought to have given your consent. And as if you read in the act, you will see according to Section 65 or 66, you ought to bring a claim before the ODPC when you get those messages.
Okay, so I think in support of what you've said, John Mwangi says, what I see some organizations do is present the recipients an option to opt out of such communication within the same message. The opt-out link is usually at the bottom of the messages. But I want to say this. Recently, I had to opt in to a particular service via message because they say I will not receive information if I don't onboard into their messages. So now what happens? I had to unlock the mother of all SMSs to come through my phone. So all other promotional messages are now coming in. When I asked this organization, is there a way to just limit the opt-in to just your organization? I don't want QuickMart to send me promotionals for rice. I don't know, it has gone down. It's good, but I don't want to know. I don't want to know who is selling what. I don't want to do all that. I think there's a way also that either it's the way we are using our phones or there's a methodology where we can completely opt out in all of these things. But then some organizations, when you opt in, it brings the mother of all other promotional messages. So how do we have strike that balance? Do we report all of them? Do I report QuickMart? Do I report Naivas because I paid via M-Pesa? Do I report Carrefour? The same? What do I do?
I think it's plain and simple. Because the moment we keep reporting these people, they will stop. And if we look at most of I've seen James saying, is it when they put out the opt-out option, is it a security against liability? They're continuing sending you out, however they say opt-out. You can opt out of this. Is it a liability, what do you call it, umbrella that they're trying to hide, even if they're trying to send their message to you about what they want you to see? Mhm. I, I think it's a learning process. You ought to report them. You're empowered. You're a data subject. You have not consented. Bring it to their attention that it is wrong.
So here comes the question that I know people are looking forward to ask. Was NHIF in order sharing my personal sensitive data with chief, whatever you call it, the Social Health Insurance Fund? I was not opted to consent to this. So let me answer this. Number one, there was a legal notice. I know sometimes we hear the bigger things like we shifted, we moved, and all that. So there was a legal notice that actually said that they can migrate your data from the old system to the new system if they verify it from the government databases that is already there. Now, the legality of that legal notice now opens another box, which now we'll have to see whether somebody's going to go to court and contest that. But they had covered it in the regulations, the Social Health Insurance Fund regulations. They had actually covered it, that they can actually, the old members of NHIF will be moved to the new system, and they are going to verify through their government databases, which now that's why you were sent a message telling us that we need to verify whether the data that is already there existing within your NHIF details is what is still currently going to exist within the new system. As I said, the legality of that legal notice, that's why this webinar is called Developments in the Data Protection Space. We'll be waiting to see what are the new developments in that. So let me see as well, there's another question, Annette. With the new chief in place in Kenya, in your opinion generally, are Kenyan citizens not being complied to give more information than they should? Want to make a comment?
Wow. Even when I was presenting, I just remembered about the NHIF scheme and everything else. It's a development, just as you've said, Muthoni. And
Yeah.
we're waiting to see what
Mm.
will happen in it. And I'm waiting to see the legals in the platform object it and take a case to court on it. Yeah.
Yeah, true. So I don't see any other question unless anybody wants to put their hand up digitally and ask the question. You can unmute yourself. Boniface Igumba says, my privacy is a human right. It's enshrined in the Constitution, Article 31. Indeed, it is a human right. So anyone else with a question? I can't see any other from the chat session. Anyone else with a question? They can unmute themselves.
Okay, thank you, Annette and Melanie. I just wanted to add something there's someone who asked about organizations that used to collect information before the Data Protection Act came into force in 2019. And as Mudhoni highlighted, the law does not operate retrospectively. But I want to highlight the meaning of data processing within our act. Different jurisdictions have different definitions, but just allow me to read the definition of data processing. In the Data Protection Act, it says that processing includes collection, recording, organization, structuring, storage, adaptation, alteration, retrieval, consultation or use, disclosure by transmission, dissemination, or otherwise making available, or alignment or combination, restriction, erasure, or distraction. So you can see within the scope of our laws, data processing is not just collecting. So you might have collected that information before the act came into force, but subsequently you're using that information, or the actions that you're performing on that data constitutes processing. So you see, you might still be found liable under the DPA, even though you collected that data before the act. I hope that makes it more clear. So the scope of the definition of processing in the Act is very wide.
So Boniface says that, in my view, a legal notice becomes an illegality the moment it violates my rights to privacy as enshrined only in the Kenyan Constitution, but as well in the Universal Declaration of Human Rights. Boniface, we do need to go to court to challenge that illegality based on even the grounds that you adduce. But right now, as we sit, it has not been challenged, unfortunately. And then John Mwangi, how about back then in 2021, before elections, when people find out that they had been registered unknowingly in political parties, why didn't the registrar sue, penalize these parties? I think there was a complaint that was made to the ODPC back then. It was actually a formal letter by a certain advocate. I'm not quite sure what happened, but that, I think, was forwarded to the ODPC to actually deal with. I remember that was information that you would find you in some political party and you are not part and parcel of that. So we will try and find out what exactly happened in that complaint. I remember it was forwarded to the ODPC. Let's see whether there was a resolution towards it. When we send you the recording of the webinar, we will definitely also put in that as a comment towards the same. So I don't see any other question, comment. I'll leave it at that. Thank you so much, everyone who has participated.